All rise, veuillez vous lever. Please be seated.
So, Maître Altit, the first question was whether we continue for the moment in open session or not.
Merci, Monsieur le Président. Nous pouvons continuer pour l'instant en session.
Thank you, Your Honor. Can we please continue in open session?
Monsieur le Président, sur ce point,
Your Honor, regarding this issue, the release of Mr. Félicien Kabuga not only has legal consequences, but it also is a humanitarian question. It has that, it encompasses that aspect. It is the legal consequence of the appeals judgment of the 7th of September, and it is also a matter of humanity. It's a humanitarian issue. Félicien Kabuga is an ill man. He's been sick for a long while, and it is absolutely crucial that he can spend time, the time that's left for him with his family. You have recalled, Your Honor, you have recalled the appeals judgment, and it is very clear, especially paragraph 75 and 76. Those two paragraphs are very important. The release of Mr. Félicien Kabuga must be a priority. This means for us that the principle of the freedom of release is an acquired principle. It is not necessary to have a specific motion by the defense on that point. The question is to just see how to proceed. That is the issue. And in order to figure out how to proceed, we have to identify a country or countries which would be susceptible reasonably to welcome Mr. Félicien Kabuga. Let's start right away, Your Honor, by excluding the option of Rwanda. First of all, I will try to summarize our position very briefly, but if your chamber wanted submissions, formal submissions on that point, it is clear that we are absolutely ready to do so. And we are ready also to explain why Rwanda is not an option. Rwanda is not a democratic country. Rwanda is a dictatorship. Rwanda does not have a judicial system which is independent and competent. Rwanda is regularly denounced by the organizations for human rights since 1994. It is denounced as a regime that kills its opponents, and a regime that arbitrarily puts in detention people who are opposed to the regime. It is a country that tries people, and the rights of the defense are not respected for those people. And it is a country which occupies a very important part of the Democratic Republic of Congo, where up until today we can witness massacres. I would like to add, when it comes to Mr. Félicien Kabuga, that he has no longer any family members in Rwanda, and when it comes to any medical help that he should need, that medical help would not be able to be given to him in Rwanda. The Rwandan medical system is not able to treat such a complex case and such a delicate case. Once again, Your Honor, if your chamber wishes us to submit to you these submissions, we can certainly submit that to you and explain why it is impossible to send Mr. Kabuga to Rwanda. Now, what are the other options, Your Honor? I would like to ask you to...
Before you move to the other options, I think it will be obvious to you, Mr. MICT-13-38, that this trial chamber could not accept the accuracy of some of the submissions you've made just now without very strong supporting evidence. And therefore, if that is a position you're going to take and it turns out to be an important position, then that undoubtedly is going to require to be dealt with in writing by submission, and we'll make that decision when we get to the end of it. But I think you'll realize that obviously without supporting evidence that these assertions are not universally obvious facts, although they may be strongly held opinions, and in some instances there may be justification. So that is, I think, what you would be required to do if you want to rely on particular submissions you've made, and I suspect you would. There are other submissions there that fall into an entirely different category, such as the fact that there are no surviving family members of Mr. Kabuga in Rwanda, which is falls into a different category, but is a force, a point in which there is force, if that is in fact an accurate statement of the position.
Merci, Monsieur le Président. Vous avez...
Thank you very much, Your Honor. You are absolutely right, and this is why I mentioned at the very beginning of my intervention that we are absolutely ready to submit to your chamber detailed written submissions with, of course, all the necessary elements to support our submissions, and we would like to bring all the necessary evidence so that you can render the right decisions. So I just wanted to very briefly summarize our position to you.
We are absolutely ready to make these submissions, MICT-13-38. So that's something that would allow us to proceed expeditiously, and I welcome that. Thank you.
Alors, Monsieur le Président,
Thank you very much, Your Honor. So what are the other options? And with your permission, I would like to ask you to go into closed session.
Very well.
We are now in open session, Your Honours.
Mr. Elderkin.
Your Honours, we just come out of private session. The defence has made certain proposals that I don't need to refer to in any detail, but we're obviously concerned with possible destination states for provisional release. I would say as a general point, the simplest way to find out if Mr. Kabuga might be admitted to a given state is to make the appropriate inquiries with the national authorities, and that would seem, given the urgency of the language used in the appeals decision, to be appropriate to be done as soon as possible. Your Honours, we've already heard in open session the defence's brief resume of their views of why provisional release to Rwanda is considered inappropriate. The prosecution does not subscribe to the description given of Rwanda by the defence, but of course we understand that there will be the potential for written submissions from the defence with supporting material, with more details, so we suggest that that discussion could be most expeditiously continue on paper. I would say, though, that as with the question of any other destination, it would seem prudent to approach the question of Rwanda in parallel with any other possibilities in order not to have a question of sequencing where one destination is considered, potentially rejected, a second one, third one is considered and rejected, going down a list without end. And it may be appropriate, whether by the defence or by the chamber proprio motu, to make the initial exploratory inquiries with the Rwandan authorities for their position on appropriate guarantees and their views on whether Mr. Kabuga is indeed entitled to return to that country, and if sufficient guarantees for any legitimate concerns can be provided. And as a broad point, obviously this institution has had experience in referring other cases, other situations to Rwanda. It's happened on several occasions with ongoing judicial proceedings to take place in Rwanda, so it's not an identical situation, but to the best of our knowledge, we've never heard that there was any negative consequence other than obviously the correct application of judicial process in those cases, but in terms of rights infringements or other issues that would cause concern for the institution, those have not arisen in those situations. The institution is more intimately familiar with monitoring individuals who have been taken to Rwanda. Those monitoring programs have been in play for legal proceedings in Rwanda, but presumably could be modified to accommodate the monitoring of the situation of somebody who were present in Rwanda under provisional release. And again, the details of those sorts of activities and monitoring systems could be continually discussed in writing.
What do you consider to be the relevance of the wish of an accused person in Mr. Kabuga's position not to go to a particular country, and in this instance to Rwanda?
Your Honour, it's an evident tension in an ideal world, and I believe the history of certainly the ICTR has been that it happens that individuals of a certain citizenship who have applied for provisional release have been happy to return to their country of citizenship. But I would understand Mr. Kabuga's overarching position to be he wishes to be at liberty. Now, the possibilities for any given person to be at liberty are different in terms of the international jurisdiction in which we reside than a domestic situation where the doors of the UNDU could simply be opened and the individual could return into the society where they're detained. In this situation, we're not there, and so providing liberty to Mr. Kabuga, potentially in Rwanda, of course, does not mean that's the end of Mr. Kabuga's story. Were that to be the most expeditious and appropriate location for him to be immediately released to, that would not presumably preclude a pathway opening up according to the necessary exploration and permissions to move to another country. And in that situation, it would be open for there to be a proposal for him to move again internationally. But the tension between Mr. Kabuga's wish standing in the way of his liberty would seem to be putting his wish, his wish should arrive in second place as compared to the appeals chamber's view, I imagine subscribed to by the trial chamber as well, that ongoing detention, because Mr. Kabuga has particular wishes that can't be accommodated, would be a tension that is unsustainable.
Well, that's rather a convoluted answer to the particular point I'm asking you about, which is what is the relevance of his wish not to go to Rwanda in deciding whether that's a place he must go to in the absence of alternatives?
But the final words are what matter. In the absence of alternatives, then liberty is liberty, if that be in Rwanda, and if there are no attendant circumstances that mean that this institution could not, in good conscience, transfer Mr. Kabuga to Rwanda, then his wishes are not relevant in that situation. he should be free first if the provisional release application or process is fulfilled, and then beyond that his freedom choices will be constrained simply by his ability to approach other countries should he be able to do so.
And if he decides not to leave when faced with that option, what do you say happens?
I would say it's a big headache for the institution, Your Honour. Somebody who doesn't wish to be free is problematic. As to what happens, then he would be in the uncomfortable situation of wishing to remain in detention, unable to be released at liberty into the host state where we are currently, and leaving the risk that his detention is inappropriate and against the correct human rights norms, that he should not be detained without purpose.
Would it be possible in those circumstances to say that it wasn't the now let me quote you the exact words. It wouldn't be identifying a state that will accept Mr. Kabuga on its territory that was the obstacle. If you look at paragraph 76 of the appeal chamber ruling, your submission was identifying a state that will accept Kabuga on its territory may present obstacles. The chamber said such a consideration may not be the basis for his continuous detention on remand. So in the situation where two countries are unwilling and there's no other option, but Rwanda is willing, he doesn't want to go, is there a difference between identifying a state is there a difference between that and the accused himself deciding not to leave? What is the reason for his continued detention in those circumstances?
Well, quite honest, I'm not sure I can identify the reason for continued detention other than squatting. But identification of a state, we don't yet know, obviously, the position of Rwanda, but if that is a state that is willing to accept him, then that falls into one box. That's possible. Should in parallel the démarches of the defence have success, then Your Honours would consider, presumably, the application formulated around another state. But should those turn out to be dead ends, then ending up in a situation where one goes through the countries of the world one by one would seem to be an extension of detention against the import of the decision, where there remains the state of Rwanda, which again, if it turns out that there are no legitimate objections that can't be cured, well, anything that can't be cured by the necessary mechanisms and orders from the chamber, then Rwanda is the country to which Mr. Kabuga could be liberated, whether he likes it or not.
Do you have anything to say on the question of whether it's a reasonable request by MICT-13-38 that the registry should engage with him in endeavouring to secure acceptance by one of the two states mentioned of the request to go there? In other words, using their good offices to facilitate the request that he's making.
I believe it may be appropriate to hear from the registry on that, as during yesterday's meeting we did, but I would leave it to them to speak for themselves.
Right, thank you. Any questions for him?
Ask him about the timing. He says I'm curious about the timing. He says he thinks we should explore the possibility while also talking about the other options. Why?
Monsieur le Président.
Your Honor. Thank you, Your Honor. Just a small word there. This is a crucial discussion. First of all, we did look at the step. Look, we said it's a duty. These are obligations. We looked at states, but that's not the point that I'm looking at here. What I want to say is very simple. The ruling of the appeals chamber is very clear. Mr. Kabuga has the right to be free. The question is how to implement this right. What the prosecution is saying is not about implementing his right to freedom. The solution proposed by the prosecution would actually lead him to be imprisoned, or at the best or at the worst, he'd disappear. So you really have to ask Mr. Kabuga what is his wish, and this has to be clearly expressed. Why are we acting as if he does not exist, if he's an object, if he could just, push him from one place to the other? If that's not what the appeals chamber is saying. The appeals chamber is saying that he is a human being and we should do the best for the little time that remains. So it's about implementing a right, and the prosecution is refusing to implement this right to freedom. They are implementing the right to condemn him to sufferings and open the doors for prosecution by the Rwandan authorities.
Well, I have to say I don't understand any part of that submission, so you would have to amplify it. Any provisional release would not entitle the country to which he is released to take any prosecution against him. And the prosecution were only answering questions I was putting. I don't think they wanted to have the questions put to them in the first place. So I'm not sure that I understand the point you're making, that they are trying to condemn him to detention.
Le droit.
The right to freedom cannot be implemented in Rwanda. It simply cannot be implemented in Rwanda.
That's not a decision that we can possibly make today or following this discussion today. Perhaps at the end of a further briefing process, which you discussed earlier, that might be possible, but not in today's context. So we've heard what both of you have to say, and I think enough has been said on the subject, but Judge de Guzman has a question for you.
Oui, je voudrais...
Judge de Guzman, I would like to understand the reply to the question that was asked to the prosecutor, that is the legal importance of the preferences of Mr. Kabuga. The appeals chamber talks about a right to liberty. The position of Félicien Kabuga is essential because he is the one who exercises his right to liberty, and he wants to exercise it somewhere else. He doesn't want to exercise it in Rwanda. If he is forced to exercise it in Rwanda, it's being contrary to his rights. The fact of forcing him to go to Rwanda is another way of detaining him. It's as if he didn't have any right to liberty. I don't know if I'm clear.
Merci.
Judge de Guzman, thank you.
Now, there is a present, a representative of the registry. The Chamber would find it helpful to have an indication from the registry of their position on the suggestion that they could use their good offices to assist the defence in their efforts to establish the necessary conditions for release to one of the two countries mentioned.
Your Honor, we are in heads of the chambers, and if we are ordered to take any actions, we will of course take any appropriate measures to execute any chamber's instruction or order to the extent possible.
So any decision would not be the result of discussion between you and Maître Altit. It would be the result of a decision being conveyed by the Chamber.
Yes, Your Honor.
Okay, thank you very much. The point has already been made that supplementary submissions in writing may be necessary. If the Chamber decides that that is the case, then these will be required within a very short period of time. And we note in particular that the defence have stated clearly that they are able to make that submission, if requested, immediately. So we will now consider what action to take in all the various submissions that have been made. We've indicated what the outcome of most of them will be, but on the crucial issues, then we will obviously have to think a little further before making our decision. But that decision and any associated order will be issued very shortly. I anticipate that being in the course of this week. So thank you for you. The only other thing I think have to raise with you, MICT-13-38, is whether there is anything you wish to say about Mr. Kabuga's current situation, and whether there are any problems that you are aware of, or whether he's drawn any to your attention with a view to raising them here.
Merci, Monsieur le Président.
MICT-13-38, thank you, Your Honour. Nothing in particular.
Received the latest UNDU medical report this morning, so our knowledge of his current circumstances is absolutely up to date. So thank you for your assistance. The Chamber is now adjourned.
All rise, veuillez vous lever.